been worked out over many situations, over many years, and really require individualized treatment. And the rule recognizes that as to both sides' obligations under the rule. Thank you, Ian.
Where it's going now, we've been in communications with the Supreme Court. The final rule, getting all the grammar together and just getting the format, it's getting prepared now. It should be going to the court soon. We'll be meeting again to sign off on everything and also to put together committee notes on it. There were a lot of lawyers involved over the last couple of years with this whole process, representing all the various organizations. And so once those committee notes are finalized, we'll be sending it over to Joe Ellen Klein, who's the legislative liaison, to get over to the Rules Committee. Yes? I'm sorry, I can't hear you.
Did your committee deal with the disclosure of a confidential
Yeah, the question was there any discussion of disclosures of the identities of confidential informants? And yes, there was. And right now, as Dave said, the fallback is open discovery. If they then move to have it certified, if they feel that that puts the investigation or a witness into jeopardy, they can move for certification, or if they feel it doesn't rise to that level, if the court doesn't feel it does, then it comes down to for counsel's eyes only, so to speak. Did I answer that correctly? Okay, did I answer the whole question? I think your question was, does that include the identity of that person? Yeah, I think that, again, this rule right now, if they've, it's really, that's the discretion that's being retained. Obviously, we would move for it, and the court would have that in-camera hearing with us prior to trial if it was an issue. Okay? I saw another hand.
And you just touched on this, but I got a bit of a problem with it. Can everybody hear me?
No.
You addressed, I want to shout. You addressed notes. Okay, I'm going to throw out 3 questions to you, and then you answer them at your leisure here. Police officers will have their notebooks, they'll make a notation. It could be a license plate number, it could be somebody that was interviewed that they just set aside. And we're not getting that. Shouldn't that be part of the rule? I file a motion for that, and I ask for the judge to rule that the prosecutor has to review the notebooks and all the notes to look for exculpatory information. Should that be included in the rule? Secondly, we're here for a homicide school. Go into a homicide, the police set up perimeters, they record plates, they call out plates. Why aren't we getting all the license plates so we can run down and see if there was somebody leaving the scene of that crime, which has happened. And they've identified people involved in murders, and twice in Shaker Heights, Ohio, this has happened. Third comment, when we file discovery in Cuyahoga, we just file a motion. But you go out to some other counties, they want you to strictly follow the rule by letter. Are we changing that, that step? And then last, if our client writes out a statement of the events, but it's incriminating, hurts us, well,
Right.
that's specifically in the rule.
Right. Here's, I think I wrote them down, Tony. I'll try and address them. The rule contemplates all the writings, the police officer summaries, reports, so on.
I heard you exclude notes.
Well, to the extent that notes could be work product. Now,
Well, that's how they withhold information. They don't put it in the prosecutor's file. They don't send it to them.
well, the current case law, which I would, because it's constitutional and not driven by statute, is that I, as the prosecutor, am responsible for anything that's in the police file.
Yeah, we discussed everything that was in the police file, and that's what was contemplated by this.
So there's, what you're talking about is really exculpatory evidence. I have an obligation under Brady to give that over under the current rule, and because it's constitutional, I would have a duty to do that in the future. In fact, the rule in my county anyway is if we have gotten past the pretrial and it's clear that the case is going to trial, my assistant prosecutor or me, if I'm trying a case, we go out to the law enforcement agency and review their file and go through their filing cabinet and the evidence locker, because at the end of the day, when this comes back on PCR 3 years from now, we're the ones that are going to be standing in front of the judge.
And you're a rare breed doing that. Nobody goes out and looks at the police officer's notes, and that's exactly what I'm asking about. Is there anything demanding that the prosecutor does this?
Yeah, everything, Tony, I'm having a hard time hearing you, but the last question, it does contemplate everything that's in that file. Now, the second question that you asked about the witnesses that are leaving, again, that would be,
License plates being called out.
sure, if something's in there, the license plates are in there, just anyone who's at a scene, basically. So you're saying the same situation, there's a fight outside, the officers say, what's everyone's names here? All the names go in the file. There may have been 20 people, but you get 2 witnesses' names. You want the other 18, right?
Yeah, you never seem to get that. You never seem to get the license plates being called out. I have to specifically demand that. I have to demand the mobile data terminal traffic. I have to demand all the radio chatter.
Well, this rule, nor any rule, is not going to end any disagreement about what falls within the purview. There are always going to be the potential for oversights. We have human beings. That's why we have defense lawyers, frankly, is to make sure that mistakes that are made or oversights, whatever different views of the same facts, are brought out to light. And this rule is not going to end disputes over discovery. But what it does do is it changes the floor of what's required, and I think presents quite a, Ian's done quite a good job for you all.
Appreciate the last part of your question was client statements, and an inculpatory statement that you have had him produce to assist you in your defense, there's no way that that goes. So,
No, I understand. What about the discovery rule? What are we going to do, by letter or by motion?
I still, yeah, just a written demand, probably the same form and fashion you do now. That's not going to change on the front end there.
To do 2 different things, that's what I was wondering.
This rule that was crafted does not contemplate any particular form of request, only really just kind of how everything's responded to. Okay? Yes?
As I understand the rule now, I'm in federal court most of the time, but in state court, you still have to reveal the identity of the witnesses and an address.
Under the current rule, you have to provide, we have to provide a list, a witness list to you, and that continues under this new proposal with, again, the same kind of issue where we have a confidential informant. We could do a certification.
Yeah, but if a confidential informant who's testifying or a confidential informant who's not testifying, because
Well, the same considerations would apply potentially to both. There is a constitutional, again, requirement that at some point, for you, in order for the defendant to have a fair trial, you have to get the identity at some point. And when that point is, has been the subject of litigation, and it